Good day to each and everyone. I am Sinemi Ampamang of BSHM3A, and today I'm going to discuss the law on sales, agency, and credit transactions. So, for our learning objectives, we have first to describe and explain the nature of sales transactions. Second is identify the functions and operations of agencies in the industry. And the last one is identify ways of handling credit transactions. And so, for our topic outline, we have the introduction, the law on sales, characteristics of a contract on sales, the effect of loss of the object in a contract, the sales of personal property payable in installments, the double sale, the obligations of the vendee, law agency, and the liability of the principal and the agent. We also have the simple loan or mutuum and the conclusions. So, what is law on sales? So, the law and sales in the tourism, travel, and hospitality industry, agreements arising from contracts will have to be made, and potential breach from these agreements will be encountered. A contract of sales, one of the usual contract being encountered by the industry concerned. This will give you an overview of the different sales transactions which may be encountered, including the remedies of the parties concerned. We also have the characteristics of a contract of sales. First is consensual, second is bilateral, third is principal, one is onerous, five is commutative, six is nominate, and lastly is transmissive of the ownership. We also have the law in Article 1458 by the contract of sale. One of the contracting parties obligates himself to transfer ownership of and to deliver the determinate thing, another to pay therefore a price certain in a money or its equivalent. So a contract of sale may be absolute or conditionals. We also have the effect of loss of the object in the contract of sales in Article 1480, that any injury to or benefit from the thing sold after the contract has been perfected, from the moment of the perfections of the contract to the time of delivery, shall be governed by articles in Article 1262, an obligation which consists in the delivery of a determinate thing shall be extinguished if it should be lost or destroyed without the fault of the debtor and before he has incurred in delay. So for the Article 1496, the ownership of the thing sold is acquired by the vendee from the moment it is delivered to him in any manner of the ways specified in Articles 1497 to 1501, or any other manner signifying an agreement that the possession is transferred from the vendor to the vendee. We also have the sales of personal property payable installments in Article 1484, that in a contract of sale of personal property, the price of which is payable in installments, the vendor may exercise any of the following remedies. So, for the exact fulfillment of the obligation should the vendee fail to pay. We have the cancel the sale should the vendee's failure to pay cover two or more installments. Third is foreclose the chattel mortgage on the thing sold. If one has been constituted, should the vendee's failure to pay cover two or more installments. In this case, he shall have no further actions against the purchaser to recover any unpaid balance of the price. Any agreements to the contrary shall be void in 1454A. We have the double sale. Caution should be practiced by real estate developers engaging in the hotel industry, especially in the real properties located in potential yet unexplored provinces. The principles on double sale will be useful in case an issue on the sale of of a real property to different vendees shall be brought before the courts of law. So we have the law on Article 1544. If the same thing should have been sold to different vendees, the owner shall be transferred to the person who may have been first taken possessions in good faith, if it is should be removable property. Should there be no inscription, the ownership shall pertain to the person who is in good faith was first in the possessions, and in the absence thereof, to the person who presents the oldest titles, provided there is good faith. In 1473. Should it be immovable property, the ownership shall belong to the persons acquiring it who is in good faith first recorded it in the registry of property. So we also have the obligations of the vendor in Article 1495. The vendor is bound to transfer the ownership of a deliver and well as warrant the thing which is the object of the sales. In Article 1496, the ownership of the thing sold is acquired by the vendee from the moment it is delivered to him. We also have for the Article 1497, the sold shall be understood as delivered when it is based in the control and possessions of the vendee. Back to the retro sale or the conventional redemptions. In Article 1601, conventional redemption shall take place when the vendor reserves the right to repurchase a thing sold, with the obligation to comply with the provisions of Article 1616 and other stipulations which may have been agreed upon in 1507. We also have the obligations of the vendee. The law in Article 1582 that the vendee is bound to accept delivery and pay the price of the thing sold at the time and place stipulated in the contract. For the Article 1582 of the Civil Code states that the buyer is obligated to receive the purchased item and pay the agreed price at the time and place specified in the sales contract. So for the law on agency, the hotel, tourism, and hospitality industry cannot do away with agencies which facilitate various transactions in dealing with third persons. Hence, there is a need to understand the operations of agencies working on behalf of the principal belonging to the hotel, tourism, and hospitality industry. The law Article 1868, by the contract of agency, a person binds himself to render some service or to do something in representations or on behalf of another, with the consent of authority of the latter in 1709. So the Article 1868 defines agency as a contract where one person or agent agrees to act on behalf of another with the principal's consent. So for the liability of the principal and the agent, for the law on Article 1883, if an agent acts in his own name, the principal has no right of actions against the persons with whom the agent has contracted, neither have such persons against the principal. In such case, the agent is the one directly bound in favor of the person with whom he has contracted, as if the transaction were his own, except when the contract involved things belonging to the principals. So in the Article 1883 of the Civil Code states that when an agent acts in their own name, they are personally liable for the contract, unless the contract involves property belonging to the principal. So for the simple loan or the mutuam, the law on Article 1956 state that no interest shall be due unless it has expressly stipulated. So the Article 1956 of the Civil Code means that a borrower is not obligated to pay interest unless it is explicitly stated in writing in a loan agreement. So I think that's all. Thank you for listening and God bless us all.